Okay, everything that you need to know about simple misdemeanor domestic violence battery. Here it is. I've said it over and over. When we're talking about domestic violence battery, we're really just talking about a simple, regular old battery where there's a special relationship to the victim. The state attorney's office can prove this battery by showing that the defendant committed an intentional striking or causing an item to strike the victim. When I say causing an item to strike the victim, I also mean causing a material to strike the victim. Now, what do I mean by causing a material to strike the victim? Well, I'll tell you, I mean spit. Broward sheriff's officers have made so many arrests for spitting in the past couple of years. It's crazy. Anyway, don't spit on your loved ones. Don't spit on your average Joe. Don't spit on emergency healthcare workers, especially, because the Broward sheriff's office is totally going to arrest you. Anyway, so getting back, simple battery gets into the domestic violence court. How? Because of the relationship of the parties, where the relationship between the defendant and the victim is considered to be one under Florida statutes as being that of a family or a household member. The case is going to get bounced into domestic violence court. And what is a family or household member? Well, this really just means spouses, husbands, wives, ex-husbands, ex-wives, people related by blood or marriage. Also included under the statute are boyfriends, girlfriends, any couple that's lived together in the past or at the time of the event. Florida defines this as living together as a family. Finally, included in family or household members under the statute are people that have a child in common together. The thing that's important to remember here is that baby mamas or baby daddies fall under the statute whether they've lived together in the past or not. So going over it again, what the state needs to prove is that a special relationship existed under the statute and that the defendant struck or caused something to strike the victim. What the state attorney's office does not have to prove in order to get a conviction against you is that the victim sustained some injury as a result of your actions, or that you actually struck the victim with your fists or with an object. For example, feeding them something gross that makes them sick will also qualify. If you feed them poison and they get so sick that they almost die, then you've just upgraded this offense to a felony. In fact, there's a number of ways that you can upgrade this offense to a felony. Using a weapon such as a knife or a firearm will result in an upgrade, which I'm sure you would have guessed. Even where a weapon was not used, these cases can be upgraded. For example, the degree and severity of injury to the victim will be taken into account when making this determination. If the victim's injury meets the definition of serious bodily injury under Florida statutes, the defendant will be looking at a felony. And even without a weapon or injury, a domestic violence battery can be filed as a felony in a couple of other situations. For example, battery on a pregnant female will always be filed as a felony. While the presiding judge would consider lack of knowledge that the victim was pregnant, defendant's knowledge is not required for the state to charge accordingly. Finally, a defendant will have the misdemeanor charges upgraded to a felony where they have previously been convicted for domestic violence battery. So remember, if you've previously been convicted for domestic violence, you better be nice to your boyfriend, girlfriend, husband, wife, whoever. So let's get back to the point. Misdemeanor domestic battery. What's so bad about getting kicked into the domestic violence court? Well, 3 things are bad about that. First of all, domestic violence cases are presided over by specially trained judges as well as being prosecuted by specially trained prosecutors. Now, these prosecutors are not going to be new rookie prosecutors assigned to a regular misdemeanor county court division. They are going to be trained and they're going to be experienced. Another thing that's not so great is that you have to deal with mandatory sentences. These must be imposed upon a defendant who is convicted. So instead of being subject to a year in jail or a year of probation, there are certain sentences that the judge will have to impose upon you. These are mandatory 5 days in jail if the victim was injured, 29 weeks of batterer's intervention, a forfeiture of the right to own a gun, and a revocation of any concealed weapons permit. Finally, if you wind up in domestic violence court and you are convicted, you're not going to be able to have your record sealed under Florida statute section 741.28. If it were a regular battery, you could. Now, what about expunging a record? There's so much confusion about this issue, it's crazy. If you do a search on the internet, you're going to read over and over that these cases may not be expunged under Florida law. Now, there is seriously some bad information out there in this regard because domestic violence battery cases that have been dismissed are eligible for record expunge. I know this. I've done this. I've obtained this for clients. Lots of attorneys have obtained this for clients. It's just bad information. You get a dismissal. You're eligible for a certificate of eligibility to expunge. So that's good news. And so let's go with this. Instead of all the bad stuff about domestic violence, let's talk about the good stuff. Here's some good news. In Florida, a majority of domestic violence cases that are filed are actually dismissed. Additionally, there's a number of factual defenses that would be available to you if you were accused. If you weren't the aggressor, if you were acting in self-defense, if the event didn't even happen at all and you can show some evidence to that effect, you can fight these charges against you. The strongest defense, however, is where the victim does not want to prosecute. And this raises an interesting point with regard to conflicting information that's out there with regard to waivers of prosecution, whether they work or not. The truth is that sometimes they do work. The thing that you need to take into consideration, though, is that going to the state attorney's office could subject the victim in the case to being questioned, threatened, or even placed under subpoena. Sometimes it's just better to tell the prosecutor over the phone. They have to prepare their case and will be reaching out to the victim at some point anyway to get ideas as to how they're going to testify. Trust me, domestic violence prosecutors deal with this on a regular basis, meaning recanting or uncooperative victims. A vast majority of these cases are dismissed because victims claim to have no memory of the event, claim that it didn't happen as described in police reports, or simply pull the shades down in their house or apartment for a couple of months and wait for the case to just go through the motions and be dismissed. Now, if you're a victim out there, don't take this as advice on how to handle the case because you got your husband or boyfriend in trouble and now you want to get them out of it. Seriously. If that's the situation, you might want to call me first so I can go into some detail about how the process works. Period. Thanks for listening. Like I said, you got any questions, call me up.